Hey, Ms. Gonzalez, are you there?
Like unmute.
Great, how are you?
I'm doing just fine. How are you
That
today?
I'm doing good. Sorry so much about this last minute stuff. I'm not in control of these people. They
No,
just
it happens a lot, and you just have to roll with the punches and know that it all comes out in the wash. So if something else will come along, or I'll have a really nice
great.
weekend. I'll have a really nice weekend now.
Wait. Sorry, I had to just close that. Um,
That's okay.
I had the Zoom feed, YouTube feed, and then it goes through a loop. I'm doing all right. So I think what we'll do here is um I just want to make it clear. I mean, so this is a case where substantively this application, and I know this only concerns you so much, but there's another bigger application they have with the commission for a bunch of utility scale solar plants. And then
Uh-huh.
this application is kind of derivative of that. Like these are two resources that they need for reliability purposes to supplement those bigger applications. So it's kind of like
It's
this
a
case
related
is
case.
exactly, and it's the less significant of the two. So I understand substantively their desire to settle this because kind of whatever they decide over another case is going to control what goes on here.
Sure.
So I mean that's the basics. So, but they shouldn't do what they've done here, which is to show up. And the reason why I feel strongly about that is in part because, look, Miss Hardy, who works for Hinkle Shanner, is a very competent lawyer. I think if anybody were to say, hey, I'm going to interfere with your capacity to make your billable hour requirements or whatever, they'd be very upset. And
Yeah.
I kind of feel like that's basically the position they put you in, which is to say, you can commit to work with us. That means you can't take other work. So that just precludes your ability to make an honest living. So do not do this.
Yeah.
There we
Yeah.
go. So I will say all that in a polite way, um, and we'll just go and see what happens.
I was talking with Anna about it, and I think it would be fair to just bill them for a late cancellation, like I would
Sure.
do anybody. So that's how I'll handle it, and hopefully they'll be okay with that. Yeah.
That's fine. Yeah. And again, it's more just to me, it's like I understand the desire to settle stuff. It's just more,
Yeah,
um, you got to do it in a timely fashion and give us adequate notice. So,
sure.
all
Yeah,
right.
no, that's fine. And are we already recording on the Zoom on the outfeed to YouTube?
Yes, we are, but that's fine. And
Okay.
I don't mind saying these. I'm going to say exactly these things in a moment anyway. So
Okay.
I'm not saying anything that wouldn't otherwise be public.
No. Nope. And I had sent you a link too. Did you get that? I felt bad. I'm like,
Real time.
yes.
I do have it here. I see it's up. Let me see if I refresh it and it captures. Oh, you
Well,
haven't
there's
been typing. So yeah.
no, but it should be blank. But I just want to make sure it worked because it's been a while since I've done one. I was actually kind of excited.
I mean, if you want to try to do some typing and just test them, I don't know, it doesn't have to be words, but I don't know if it's running at the moment or not. There you go.
Oh, well,
Perfect.
that's not good.
No, it's working on my end. It's working.
Yeah. Yeah, but I wrote something like weirds.
Yeah, no, that's fine. So real time, and I will tell you, like Anna, Miss Kippenbrock asked us about, I just had Mr. Lee, your brother, for the 2258 case, and
Yeah.
real time is so helpful because invariably, as the hearing examiner, and particularly with virtual hearings, right?
Hmm.
You're multitasking like crazy, and you're
Yeah.
paying attention to who's in the waiting room, and maybe somebody's trying to like send an email to you, like the commissioner, can you let me in? This kind of thing.
Yeah.
So invariably, your attention will be taken away from the speaking, and then inevitably they're like, "Oh, objection," and then you're like, "Okay, well, what do they object to?" And let me go look and understand all this.
Yeah.
And that's just like one limited example. I mean, it's that happens to me time and time again. So I think real time, what I've said and what Anthony has said is all of our hearing examiners should be using it all the time, and the commission should just budget for that to be incorporated in every hearing.
Yeah.
So
Yeah.
it's very
It
useful.
it takes a lot of prep time. Like I went through, so Anna sends me her prep, right? What she finds. And then I went through looking at witnesses. That's why it's helpful to have those and found some other words so that I put them in there so that and then it would be helpful to know to limit because I don't know what, I don't know. I know you guys read all this stuff and then you ask your questions and you're not going to go over everything I'm looking at.
Mm,
But what I did is, I went through, I at least found out, where everybody worked, because that's gonna come up, because so much of what I write has to be found and put in. So anything I do beforehand just means you're gonna be able to read it if I write it consistently,
I see.
right?
Okay.
Yeah, and so if I know, like, if somebody's gonna say, oh, I can't think of, like FERC, like if I didn't know that FERC was FERC, it might come out FIRK in
Right.
steno for you. So,
Right.
that, so yeah, so you do some prep time, but I think it helps because it helps me on the back end when I'm trying to hurry and get the transcript done. Or
Yeah.
when
And
I'm,
I understand your point exactly.
yeah. So I used to caption for television,
Okay.
and you have to do that prep. It like you can't do, basketball games. You can't just put the Suns players in. You need the whole roster of every team
Right.
for the
Right.
season,
Well, and just, and for your benefit, I mean, to the extent to which, Mr. Lee yesterday, David, he feel free to interrupt at any time when people start throwing out acronyms or abbreviations, because they are absolutely endless, and
Yeah.
it just takes time and exposure to this stuff to
Yeah.
capture them all. And it's like, it's really hard to anticipate even what some folks will say. So I have absolutely no bones about you or David or anyone really just being like, wait, what is those words? What does that
Yeah.
abbreviation mean? So
The hardest, usually if they'll say that word and then, I'm listening and putting comma and then the next thing, like if they say long-term purchase
purchase
power
power
agreement,
agreement. Yeah.
or LT,
LTPPA. Yeah.
yeah, then I'll get it. And then,
Right.
you know what I mean? But I'm already because I know it's real time, I'm gonna prep that anyway, as much
Well,
as I can.
David just did our grid mod, and it was grid modernization, right? And so what is grid modernization? It's just basically a whole host of technologies to modernize
Mhm.
the electric distribution system, which is what you and I utilize to get power to our homes. And it's just endless abbreviations.
Mhm.
Like, and I'm not kidding, like endless. Like, the fact that David didn't just explode his head. It's because it's telecommunications work
Yeah.
ultimately. That's what that technology is.
Yeah.
It's your meter on your home communicating with the utility system central server, really, and then real time understanding, if you've got a solar panel on your house, how much electricity are you generating at home, and what do they need to do with that in order to have balance on the distribution system, which is wild. I mean, just think about that for a minute and multiply that over 500,000 people.
Yeah.
It's
Oh
truly
gosh.
like magic. Like, so anyway, I'll stop there. All right, I'll let you go, and I will. I
All
see one
right.
person in the waiting room, and I can hear you fine. And it sounds like you can hear me fine.
Yes. So,
I
all
don't know how
right.
long we'll go. It might be fairly quick. It might not be. I'm just going to go through. I have my own little schedule of stuff to address. But my understanding is they're going to ask for a break. And my intention is just to say, like, look, if you guys are going to file a stipulation, we probably just need to reschedule this and for another date, and we'll figure out what that's going to be.
Sure, that sounds good. I'll just put myself on mute and on stop video, but I'll be sitting here and I'll watch. When you come on,
Terrific.
I'll
Thank
come
you.
on.
Yep. Okay. Bye.
Mr. Hearing Examiner, can you hear me?
I can, Mr. Bagacco.
Thank you.
And it is 9 a.m. Ms. Gonzalez, are we ready?
Yes.
Terrific. So we're on the record here. Good morning, everyone. This is the public hearing for case number 23-00384 UT, the Southwestern Public Service Company's application for long-term purchase power agreements. Today is Thursday, April 25th, 2024. My name is Christopher P. Ryan. I was appointed as the hearing examiner to preside over this case. Start with appearances, and this way we can test everyone's mics are working as well. SPS.
Good morning, Mr. Examiner. Dana Hardy with Kinkle Shaner on behalf of SPS. And also appearing for SPS are Ms. Andrea Stover and Mr. Landon Little. And Jimmy Skipton is also on.
Great. Occidental Permian. Is that the full name of the company, sir?
It's Occidental Permian Limited, Your Honor.
Great.
And Michael McMillan for OPL.
Perfect. The New Mexico Large Customer Group.
Good morning, Your Honor. Nick Stoffel with the law firm of Holland and Hart on behalf of the New Mexico Large Customer Group. I'd also like to enter the appearance of my colleague, Austin Rushoff.
Okay. CCAE, that's the Coalition for Clean and Affordable Energy.
Good morning, hearing examiner. I think you can hear me. I'm here representing Coalition for Clean Affordable Energy.
And that's Ms. Carol Lynch.
Yes.
Yes, and I can't hear you. Thank you. LES, which I hope I'm correct, Louisiana Energy Services?
That's correct. This is Joan Drake with Module Sperling representing LES. With me today also is Susan Miller, also representing LES. And just for your information, I'll probably be dropping off the Zoom, and Ms. Miller will stay on representing LES.
Okay, thank you. And staff.
Good morning, Mr. Hearing Examiner. John Bagacco appearing for the New Mexico Public Regulation Commission Utility Division staff.
I didn't miss anyone, did I? Don't think so. Good. All right, next. There are no public comments. I received an email from our paralegal for the Hearing Examiners Division, Ms. Anna Kippenbrock. There was notice given that an opportunity for public comment would be possible at the beginning of this proceeding. No one communicated with us that they wish to do that. All right, so now we'll get into yesterday afternoon. I received a telephone call from Ms. Hardy. I was in the middle of the PNM grid modernization supplemental hearings on that company's benefit cost analysis. So at about, I forget what time it was. I'm going to say it was about 12:15 or 12:30 or something like that. Maybe it was a little bit later. Anyway, Ms. Hardy alerted me that there was discussion about a stipulation or a settlement in this case, and the parties were going to be further discussing that afternoon. I informed her that she should just keep me apprised of the discussions. And then it was a very long day of hearing yesterday. We went until about 5:30-ish, longer than we had to. Mr. Lee, actually, interestingly enough, is Ms. Gonzalez's brother. So our court reporters are very, very capable people, and we are very, very lucky to have them working with us. And Mr. Lee volunteered to go late. So I did see a telephone call come into my phone, my commission cell phone, from Ms. Hardy, and she indicated that today the parties intended to appear and then ask for additional time, as I understand today, to discuss a stipulation. And I'm happy to hear more about this in a second, but I just want to say a few things first. And Ms. Gonzalez and I were as I was checking in to make sure my audio worked, and she was, you know, could hear me and I could hear her, all that. We're talking about this. So I'm well aware, and I've been at the commission now almost 5 years, and I understand the nature of settlement negotiations, and you all can't necessarily at all times resolve all of that within a period of time. But the problem on our side is that, and then this is in my mind the most pressing concern. I'm at the commission. I'm a salaried employee, whatever. I'm there, and I understand. In this case, it's kind of an interesting example because you have this matter, and then you have 23-252. And as I read the testimony and the stuff that I was going to ask at today's hearing was going to be like, well, isn't this sort of derivative, and doesn't the commission's decisions there sort of guide what we do here, given the nature of these resources in relation to those proposed in 252, et cetera, et cetera. So I get that that's like where we are substantively, but then just as a practical matter, you know, first of all, this case was an expedited transcript request. And so what does that mean? That means that Ms. Gonzalez goes out and procures the assistance of people who, while she's typing, are in the background verifying what it is that she is typing to ensure its accuracy. So in other words, we see Ms. Gonzalez, but we do not see the other people contributing to the effort to completing the transcript in a very quick fashion. And so she has to commit people's time and resources to this proceeding. And she, of course, herself has committed time and her resources to this proceeding. And I can assume that all of you out there in the land of billable hours are totally aware of, you know, just the pressure to make a living and not have folks interfere with your projected business models. That's ultimately the principal concern about late filed stipulations, as far as I'm concerned. I mean, the commission's substantive adjudications and what we're going to decide on the merits is, we'll get there. I mean, I was prepared to decide this case, even though I was assigned 50 days after the 180-day period. We're just going to get it done. Somebody drops the ball, you pick it up, you run. But you know, I'm just very sensitive to the fact. And here's another thing to remember. Like, so as Ms. Gonzalez and I were speaking before we got on today, what does she do in the times leading up to our hearing? Well, what she was describing to me is that when she's working in her machines that allow her to do her court reporting, there's like, she can create functions where she like identifies words and stuff and has knowledge herself. And it's important for her to know, like FERC, right? Federal Energy Regulatory Commission, understand what that is. LTPPA, understand what that is. And I go fast. And everyone wants to go fast when they do those abbreviations because that's what our brains are doing. So she's doing all this prep, right? She's preparing for this. And it's like, that takes time, and it takes effort, and it takes labor. And then the other part I'll tell you is there's a lot of court reporters who don't want this work. Nobody wants to figure out what SCADA, IVVM, DERMS, ELCC, all of these acronyms and abbreviations mean. They don't want to do it. So we have had a very trying time keeping court reporters at the commission. And Mr. Lee and Ms. Gonzalez are competent people, and we're going to keep them. So what I'm telling you all is I'm going to make sure that they're taken care of. Whatever the hell I have to do, I'm just going to do it. So I'm sorry if that bothers anybody, but that's my perspective on the subject. She's the most important person in the room, and that's just how it is. So that being said, let's hear about, and there's more to be said substantively in terms of the rules on stipulations and what we're doing there. And some of you are familiar with what the commission did in the New Mexico Gas Company case in terms of having that public hearing and requiring presentation. And I can describe all that stuff at length, and I'm not going to get into that case necessarily, but what are the concerns surrounding stipulations and how we do them at the commission. So Ms. Hardy, why don't you tell me where we are?
Thank you, Mr. Examiner. And I want to start by saying we understand the concern, and SPS is happy to compensate the court reporter and make sure that everyone is fairly treated.
Very good. Thank you, Ms.
Hardy.
Hardy.
Of course, we understand that. The parties are still discussing a stipulation. I think that if we could have a couple of hours, and maybe adjourn until this afternoon, we should know. I think there are a couple parties we haven't heard from, and we really need to know their position. Other parties have agreed to the terms that have been discussed. So I think we are close and could just use a little bit more time.
Okay, and so as far as timing is concerned, to come back this afternoon, that you coming back would only be, I assume, to tell me that we have reached a stipulation, and then there will be subsequent proceedings in which you provide me testimony and all this type of stuff as to support the stipulation. Is that correct?
That's correct. And if we haven't reached a stipulation, I think we're prepared to proceed with our evidence.
Okay, I understand. If there is a stipulation, Ms. Hardy, I assume the company is also willing to waive whatever tolling or waive the rule requirement to have this case adjudicated. It's my desire not to get in the way. I'm only interested in getting these cases done for the commission to be working as efficiently as it possibly can. But to the extent to which logistics require us to go beyond whatever deadline exists, is that the company amenable to that?
SPS would absolutely agree to a 30-day tolling of the decision period.
Okay.
Mr. Hearing Examiner,
Mr. Bagacco.
I can say this. I mean, staff's concerned about the rush, the last minute nature of this. We're cognizant of your decretal paragraph G in the procedural order. We're cognizant of the 6-month deadline in Rule 551, notwithstanding SPS's willingness to push it out 30 days. We did receive additional terms yesterday, and my team's had a chance to look it over. And I can say right here and now, they're not interested. I mean, they would like to go forward with this hearing. If you order us to participate in stipulation discussions, we will. But this seems to be a recurring pattern. And I know we have a short deadline in this case, but staff is increasingly skeptical of these stipulation talks. And certainly they don't find the proposition that these stipulations somehow contribute to the efficiency of proceedings or the conservation of resources to be believable anymore, especially under these circumstances. And so overnight, they had a chance to consider what was tendered yesterday, and they'd prefer to go forward with the public hearing. And I know everybody else wants to get on this bus and ride it down Stipulation Avenue, but I think we've come to the point where we're not going to agree to anything because, okay, you push this out 30 days, but what's the impact on everything else in terms of efficiency? We also have other cases we're working on that crowds our schedule, that crowds our planning. And certainly it's going to require the creation of a stipulation that'll have to be built out and filed, creation of a new procedural schedule, I take it, to address the testimony that will be necessarily required to support the stipulation. And then another public hearing setting. And I appreciate what you said earlier about the court reporter. I mean, we're to the point now that I think, for the foreseeable future, they might not even want to entertain talks about stipulations, because a couple cases back, there was one where it seems like we went round and round for a little bit and nothing happened. Some cases are more amenable to stipulations than others. But here, under this scheduling crunch and everything else I just mentioned in terms of the fallout from this and the knock-on effect of staff's schedule and its other commitments, it's kind of like staff is left in the position then, okay, sure, maybe you concede to some things that are consistent with positions taken by certain parties in the case. But really, everything else being equal, what does that give us? What advantage do we gain? What's in it for us? And it's come to the point where we're going to have to start asserting ourselves a little more in that respect and thinking that way. I know we try to balance the public interest, but at the end of the day, getting drug into stipulation talks and pressured to agree to things that really don't end up realizing any efficiencies or the conservation of resources is increasingly leaving a badder and badder taste in staff's mouth. And so that's where we are. Maybe I should have sent an email out late last night to everybody saying
No.
that, but they had to consider what was provided late yesterday, because every time somebody sends me something, I take it to my clients and they give it due consideration. Now, increasingly, they feel like their backs are up against the wall. And just because everybody wants to sit around the campfire and sing Kumbaya doesn't necessarily mean we're going to be joining that campfire ring in the near future or the foreseeable future, because this is just, staff's frustrated. And I'm just carrying the message and the feelings of my clients into this forum so that everybody can be on notice going forward.
No,
And
thank
so
you, Mr.
I think
Bagacko.
it's our preference to proceed with the public hearing today.
Okay, I appreciate you doing that on the record and with our court reporter present and having that stated in a way that it will be formalized in a legal document. So good. And you know what I'll tell you all, you know, you're certainly probably aware of what happened in the New Mexico gas case company's last rate case, in which the commission held a hearing where the gas company presented, you know, its stipulation, and so what's going on there, right? Like I've written about this, and it was the gas company case that I did with Elizabeth Hurst, hearing examiner Hurst. Fundamentally, you are not litigants and holders of private rights coming to an adjudicator, private rights to an adjudicatory body that is here to decide private rights, right? This is not a tort, right? Like this isn't a plaintiff versus a defendant. The commission has a role in every case, including in settlements, to decide whether or not the resolution is consistent with the public interest and whatever other governing legal standards exist for the type of application that is brought to the commission. In every case, they have to decide this. And what I can assure you, that these professional commissioners, if you watch the grid mod proceedings, these folks know a lot. And Mr. Commissioner Ellison's participation is just, yesterday I made the mistake of saying, I thought IVVM, there's a, what is it? It's, I forget the exact, with those, it's voltage, but then it's volt var something. And I'm like, what does var mean? And I'm like, is that var like a abbreviation for variation? Because it seems like that's what the nature of this thing is. Like, oh, no. This var is this thing. And it launches into this long discussion of what var is, which is an electrical concept, which is beyond me. But I mean, so that's where they are. And there's a great sense of uncertainty about whether or not stipulations are being utilized to bypass the commission's discretion in all these cases. And I'm not speaking of any specific individual, but that exists. And so all the stuff that Mr. Bagacko just said, I can assure you those conversations are happening elsewhere. And you know what you're seeing play out at the commission reflects a concern about that, which in my opinion is completely legitimate. So I guess, Ms. Hardy, what do you want to do? You've heard what Mr. Bagacko just said. What do you feel is the next step?
Your Honor, if I could have an opportunity to weigh in as well.
Mr. Stoffel, okay, do you want to go first?
Yes, thank you. So absolutely understand and hear where you and staff are coming from, and just would like to take an opportunity to kind of zoom out and recognize the circumstances that we're in here. So this is a relatively straightforward case in terms of a PPA approval, but as you noted earlier, it has the complication of having related or similar issues in a separate proceeding that's currently pending in front of the commission that has a recommended decision, but not a final decision issued, and exceptions due this week. And so we did not have quite the ability to rely on that prior decision as guiding what the outcome should be here as we come into this hearing. And we also got the rebuttal testimony in this case just last Monday. So that gave us a very tight window to even initiate settlement discussions, to be able to evaluate the different issues here and the potential implications for the CCN approval case, and to be able to come to an agreement, which several of the parties have been able to do. And ultimately, the nature of the settlement we were talking about here is very straightforward and simple. And it would make resolution of this case very easy because it is within the evidence, absolutely. And it would provide a straightforward path to approval for these resources that the company has clearly indicated it needs to be able to serve its growing load in New Mexico. And so, without disrespect to what you have said and what we've heard from staff, I would ask on behalf of my clients that you do consider giving us this additional time, allow us to have this conversation with Mr. Bogatko separately, allow us to have this conversation with anybody else who has not yet indicated their willingness to join or not oppose this settlement. And I say all that because either then we'll resume this afternoon in a contested hearing, or I think given the nature of the settlement we're talking about, we will be able to prepare a very short schedule for consideration of the stipulation. And I think ultimately, if we're able to present that to you, it will become apparent that it provides for a very straightforward resolution of this proceeding.
Thank you, Mr. Stoffel. Yeah, I appreciate that. And I'm not trying to lecture anybody either. I'm just more, the law ends up pushing us into weird places, right?
Well, fully understand. And I know we're all dealing with the time that was lost at the outset of this case.
Right.
Recognize that both you wanted to hold to that timeline, but your order also indicated some flexibility for consideration of a potential settlement. And so that's what gave us the belief, at least certainly from an NMLCG perspective, that you would entertain this kind of change in the process. But certainly understand where you're coming from, certainly understand the disruption for the court reporter, understand staff is incredibly busy. They have multiple cases, but just wanting to put this specific discussion in context of this case and the related case.
No, I understand. And sorry, go ahead. Someone else was trying to chime in.
Mr. Hearing Examiner, I understand Mr. Stoffel's perspective and I understand his analysis, and I, to a degree, have some empathy for that. I'm coming up off the top of my head with a possible solution that doesn't send us back into the territory that I outlined earlier. Is that back in the old days in federal and district court, I mean, if people want to agree on things in a case, then they could stipulate to those things on the record, or in the midst of giving live testimony on the stand today, they can say what they agree with and eliminate those issues in the course of the public hearing. I don't know if that's something that's procedurally amenable with how we do things here at the commission, which is not identical to how we do things in other legal venues, but I'm just throwing that out there because if people agree to things, there's nothing that stops them saying so on the record, or, if we could back up in time in rebuttal. That's happened before in cases where we at least circle up with each other and close down some issues and make them, at least between those parties, not a controversy. That's another way of handling it. I don't know how you'd feel, though, about what the record would look like with that sort of off-the-cuff maneuvering, but that's something I'm just throwing out there because notwithstanding the things that Mr. Stoffel's elucidated, and I understand that we are in the position we are because of a number of different factors, I'm trying to come up with a way to just move forward and to avoid all of those inefficiencies that staff perceives, even with the truncated schedule.
Yeah, I mean, one of the thoughts I had as we were all talking is, the rules provide for both contested and uncontested stipulations. And what's interesting is that, the holder of the application, to the extent to which they can procure agreement on some matters that others in the case may oppose, still have the capacity and the theoretically right to supply the contested stipulation. And then what do our rules say? The rules say that the commissioner presiding officer shall schedule the stipulation for public hearing. And I've sort of focused on those words previously and thinking about these settlement issues in our adjudications. And mean, the word shall is usually one that's used, it's mandatory, right? So, the commissions, that there is an effort to revise a lot of the rules in 1.2. But what our rules appear to say now is that if SBS and the parties elect to file a contested stipulation, they hold a right to do so, and then our rules require the commission to have the proceeding on that contested stipulation. Do I think that's a great idea? Well, it doesn't really matter. The rules are rules, as allegedly what Supreme Court justice I had my federal courts professor in law school was, who did he work for? I can't remember. It was Thurgood Marshall, actually. I remember him saying at one point in time, like, rules is rules, apparently he would say to his clerks. Anyway. So I don't know. So Ms. Hardy, does the applicant have a prerogative?
Mr. Examiner, I understand staff's concern, and I agree with Mr. Stoffel that this would be a simple stipulation if we're able to reach it, and several of the parties have already signed on. I do think it would be very helpful if we could just adjourn the hearing until this afternoon, and at that point we could advise you whether we have an agreement or not, and if not, we can go forward. But I think that extra time would be helpful for the parties. I think that we would need, for purposes of the record, to have a stipulation rather than just going on the record this morning and saying whether we agree with certain matters. I think that would create a confusing record, given that there already is testimony and that the parties would be basically amending their testimony based on the agreement. So I think it makes more sense to have a written stipulation for purposes of the record. And I do think it's a simple stipulation. I think testimony in support of the stipulation would be short and straightforward. I think it would streamline the hearing for the parties and Your Honor, and ultimately the commission's decision.
I'm sorry, can you speak up? I'm not sure. I'm not hearing
Yeah,
you.
I wasn't hearing you too well either, Ms. Hardy.
Sorry about that. Let me.
That's why I go with the air traffic control looking headphones. They give you that little jawbone mic and you get to play ATC guy for the day.
Is that better?
Yeah, it is.
Okay. Apologies for that.
No problem.
I was saying that I understand staff's concern and I agree with Mr. Stoffel. I think that this stipulation would be very straightforward and we just need a little bit more time to see if we can hammer it out. I think it would be very workable for the parties to come back this afternoon after lunch and advise Your Honor whether we have reached agreement or whether we need to proceed with the hearing. I do think we need a written stipulation in the record rather than proceeding with the hearing and just having the parties state whether they agree with certain items, because there is testimony already submitted on these issues that would need to be amended based on the stipulation.
I guess part of my point and what I was trying to convey to you, Ms. Hardy, is that in some ways you have rights as the applicant, utility applicant, and you have to decide for yourself whether you're going to go forward with a contested stip, and I'm giving you the opportunity to decide. I mean, I think the time what I guess I'm most comfortable saying to you is that you're entitled to have the time to go decide if that's what you're going to go do.
Correct. And Mr. Examiner, thank you. I think that the additional time would allow SPS to make that determination as well, because right now I don't know
Okay.
whether we would go forward.
Yeah, sorry, I didn't mean to cut you off.
That's okay. I was saying I don't know right now whether we would want to go forward with a contested stipulation or not.
Okay. Does anyone else have anything to say on the subject?
Mr. Hearing Examiner, is it going to be a simple adjournment or are you going to order it?
I mean, for the present moment, I mean, unless you have a preference, Mr. Bagacco, my view would be we'll do what Ms. Hardy just suggested, which is to break and come back at 1. Is that acceptable? 1 o'clock p.m., Ms. Hardy?
That would be acceptable. Thank you.
And
yes.
and then see where we are. Ms. Hardy can tell us if the company's moving forward on a contested stip, and if that's not happening, then I guess we move forward on the hearing at 1 p.m. Is that acceptable, Mr. Begacco?
I can't say it's acceptable to staff, but I mean, we've set forth our position, and I can say staff is not enthused or happy, but we will. I think staff would view this as an order for them to participate in settlement discussions, and if it's couched in those terms, then staff will go ahead and do it. So if you're amenable to that, I would please ask that you order such so that at least staff has something concrete to proceed from, because this has been very difficult for them. And I think no matter how this turns out, it's going to have some fallout in the terms of how staff views these things going forward.
Sure, I understand. And I think, Mr. Begacco, I ultimately too, whatever we order staff, the commission staff to do, Ms. Hardy and the other parties can just carry it forward, right? They have the ability to do that. And
correct. I guess I'm putting it in terms of, staff will do it not under protest, but certainly not. Like I said, I don't know how else I can verbalize their feelings about this.
Sure.
And how this is not a good deal for them no matter what, because of the things that have to happen on the back end. So people who claim that there are efficiencies in doing these things going forward are going to be met with an increasing level of skepticism, because I've seen these hearings now where supposedly we get a stipulation and we end up being in a hearing that takes just as long, if not longer in some instances, I think, than one where we just do a straight litigated case. So if you would please order staff to participate in the settlement conferences, we can conduct ourselves accordingly. I think that's just, that would be my preference. And for the benefit of my clients, I would ask you to do that.
that's fine. I'm happy to. I will do that on the fly, which shouldn't take me too long to put that together and file that
An
order.
oral order would be acceptable. I would accept that, and we would honor it.
Okay. Well, Mr. Begacco, I think, right. Why don't we just, all the things you've just said, so I won't try to repeat them all. Let's have staff at least participate, and to the extent to which staff is uninterested in agreeing to the stipulation, you're free to do so, but at least we'll go and hear whatever they're going to try to convince you of and leave it at that and come back in the afternoon. Is that an acceptable statement, Mr. Begacco?
That'll suffice. Thank you very much.
All right. Anything further from the parties before I just want to confirm with Ms. Gonzalez that, this is all going to work with her? She's nodding her head. So if there's nothing further, then let's just adjourn here. You all go communicate in whatever fashion is going to be most productive to deciding what we're doing. And we will resume at 1:00 p.m. And we'll move forward however you all. I mean, I just have to wait and see. We'll see what happens. But in any case, we will return at 1:00 this afternoon.
Thank you, Mr. Examiner.
Sure. All right. Well, we'll see you all then, and we'll go off the record till then. Thank you.